I'm Jennifer Turner, human rights researcher at the American Civil Liberties Union. I'm sorry I'm not able to attend this event in person. I'm grateful for the opportunity to provide some remarks through videotape. Today I'm going to talk about life sentences in the United States, and I'll start with providing an overview on data on the numbers of people sentenced to life and life without parole, and then provide some information about the key policies that have been driving the increase in the use of these sentences in the United States. And I'll conclude with a few recommendations and good practices to reduce the use of these sentences. Now, in the United States, nearly 162,000 prisoners, that's 1 of every 9 people in prison, are serving life sentences today. Those serving life sentences in the United States account for nearly 1/3 of all life sentence prisoners around the world. The Sentencing Project has found that an additional 44,311 people are serving de facto sentences, life sentences of 50 years or more. These are sentences that exceed the convicted person's natural lifespan. Together, those serving life and de facto life sentences represent nearly 14% of the U.S. prison population, or 1 in 7 people behind bars. And nearly half of people serving these de facto life sentences are Black. Today, the number of people serving life sentences in the U.S. is higher than ever before, having increased nearly 5-fold since 1984. Life sentences have increased exponentially, even though violent crime has declined sharply throughout the United States during that period, and prison populations have generally been declining since 2010. Life without parole sentences have risen nearly 4 times as quickly as parole-eligible life sentences, and more than 1/3 of the people serving the life term have been sentenced to life imprisonment without the possibility of parole in the United States. The population serving life without parole has more than tripled since 1992 to 53,290 people. In addition, nearly 12,000 people have been sentenced to life or de facto life for crimes committed as juveniles, and over 2,300 of these people are serving life without parole for crimes they committed as kids. More than 17,000 of those serving life or de facto life sentences were convicted of nonviolent crimes. Our research found that as of 2013, 3,262 people were serving life without parole for a nonviolent crime. These are nonviolent drug and property crimes. And many of those serving life without parole were serving it for their first criminal conviction. And about half were sentenced under habitual offender laws, and over 65% are Black. Our research documented the cases of people serving life without parole under 3 strikes laws for incredibly petty nonviolent offenses, including, for example, serving as a middleman in the sale of $20 worth of marijuana, siphoning gasoline from a truck, breaking into a parked car and stealing a bagged lunch, shoplifting 3 belts from a store, stealing a box of candy from an unlocked office building, attempting to cash a stolen check, and possessing a bottle cap smeared with heroin residue. Now, life without parole was virtually non-existent in the United States before the 1970s, but it became prominent in the United States following the Supreme Court's ruling in 1972 in Furman v. Georgia, which temporarily abolished the death penalty. And since then, there's been an explosive growth in the use of life and life without parole sentences in the United States, generally since the mid-1970s. This growth has largely been because of tough-on-crime policies that drove state and federal legislatures to pass laws creating draconian sentencing and parole schemes. Because of these policies, the average time served for all major categories of crime has increased in the vast majority of states over the last 3 decades. Now, there are 2 main categories of policies that are driving the exponential increase in life and life without parole sentences in the United States. First, at the front end, excessively punitive prosecutorial practices and harsh sentencing laws such as habitual offender laws, mandatory minimums, and other harsh determinate sentencing laws have driven these sentences. At the back end, limitations on release such as truth in sentencing laws and other policies that increase the amount of time that prisoners must serve before becoming eligible for parole, as well as the abolition of parole, the creation of categories of crimes that are simply ineligible for release, and the declining chances of release through parole, even for parole-eligible prisoners, has also driven the increase in these sentences. Now, in terms of recommendations for how to reduce the imposition of these sentences, sentencing reform, of course, is essential. Congress and state legislatures should enact comprehensive sentencing reform legislation, including reform of mandatory minimums and three-strike laws, as well as these laws need to be retroactive to apply to people currently serving life sentences. In addition, parole reform is essential. We need to adopt or expand presumptive parole models, such as exist in the state of South Dakota, where the burden is on the parole board to provide evidence for why a person needs to remain in prison. Under this system, parole applicants would be released at the parole eligibility date unless the parole board, in consultation with the Department of Corrections and having reviewed the individual's record while incarcerated, objects. We also need to eliminate the ability of governors to block the release of an individual whom the parole board has approved for release. And if parole is denied, we need to provide the parole applicant with an opportunity to be reviewed again at regular intervals to measure their progress. And lastly, we need to expand existing mechanisms for sentence reductions in appropriate individual cases. Decision makers have to have the discretion to review individual cases and determine when it's appropriate to release prisoners, many of whom have served decades for crimes that merit shorter prison terms. There are a couple of ways to accomplish this. One is to expand executive clemency, in which the president or a state governor may order a commutation of sentence. We also need to create and expand second look mechanisms. These are mechanisms by which a judge or judicial panel may revisit the sentence of a prisoner who served 15 years or more, or some other period of time in prison, and decide if under present circumstances a lower sentence better serves the purposes of sentencing. Thank you again for having me, and I wish you all a very great panel.